within the juvenile justice system, and then second, what to do, and what some reflections on the what to do question. Okay, let's go to the first. How do systematic inequalities or discrimination matter work within the juvenile justice system? I will focus on 4 moments, in fact, in the practice of juvenile justice as a system, let's say, having a system, meaning you have a framework of law and laws, the law, but you also have actors and you have moments where decisions are taken, where young people come into contact with several, can be procedural moments, but also can be moments of, for example, leaving a juvenile justice system. So I will focus on those 4 moments. Can we go to the third slide, please? So the first one is about the logic of the system itself. One of the interesting historical characteristics of a juvenile justice system in Western Europe, at least, is the fact that this juvenile justice system is based on the idea, which is an idea that comes from the 19th century and the social defense thinking, the idea that we have a lot of structural problems in society, poverty, precarity, inequality. But those big social and societal problems are have an expression at an individual level. And the juvenile justice system, at least the Belgian system, and I think some other West European systems of juvenile justice, have, in fact, the perspective on the problem, being delinquency or being non-delinquent problematic children. The perspective that is in the system is that the structural problems are individual problems. So young people come into contact with juvenile justice system as way of being a problematic child, having characteristics that are individual problems. And the juvenile justice system is going to, let's say, tackle those. The intervention is legitimated because of those individual problems. So the logic of the system in itself has already embedded, deeply embedded, the idea that through the juvenile justice system, those problematic behaviors, which a delinquent act is, but the delinquent act is seen as a symptom of something that is behind, more in the socialization, in the education, in the living conditions of young people. So you have this sort of tunnel vision, in fact, which brings in an individual in the view of the system, but of course, the system is not intervening towards more larger structural problems. And it's not these societal problems that are going to be taken into account in tackling young people. So it's clear, and historically has been really, let's say for Belgium at least, it's more than 100 years, the clientele of the juvenile justice system is a clientele that is really already in this inequality in society selected. So it's going to be, I'm not saying, because we can all give some examples of children from middle classes or children from more higher social economic status families. They are also sometimes come into contact with the system, of course, but it's not the average, the profile of the classical client of the system. They have other and will have on other moments another way of being treated by the juvenile justice system. Can we go to the next slide, please? The second very important element is that it's not just at the level of the logic of the system, which makes it a selectivity towards what kind of populations are the classical populations of the juvenile justice system. It is also in practice that the juvenile justice system, in its largely, from the police up until the execution of measures and decisions in institutions, there is a sort of selectivity in the working of the system. Of course, the most classical example for criminologists is the fact that young people who come in contact with policing, for example, are young people from minorities, from neighborhoods where poverty is a key characteristic, a certain social class, certain ethnic background, but also in territorial, as I said, certain neighborhoods. So this usual suspect element is very important and makes a selectivity to coming into conflict with the system very clear. So you have a sort of overrepresentation of certain groups in the system by way of how the system works, operates at its entrance. It's also about young people visible in the space. It's public space. It's young people that have, for example, no classical organized are not, for example, in football clubs, or so young people hanging around, especially in urban settings, public space, are more at risk of being to come in contact with policing, but also, for example, young people who have problems with schools and are outside of schools, young people who are not under the supervision of adults, professional or non-professional adults, have a higher risk of coming into contact with the system. It's interesting to see that these groups are more vulnerable for entering the system precisely because they don't speak the same, let's say, language of power. I'm not going into that, but it's every moment in coming into contact and decisional moment is a moment of strategic communication and interaction. And so young people who are not skilled to talk to authority have a higher risk of being taken by the system into a sort of more interventionist trajectory. I point out the interesting publication of Cuneen, who is an Australian colleague and had done research on how race works in the juvenile justice system in Australia. And he uses the term of racialization. And I will come more to that because I don't have really much time, of course, so I don't want to go into that more in detail. But I would say this term is interesting because he demonstrates how this ethnic discrimination, you could say racism, it's not about that the system is racist, but race has become a sort of risk factor that's started to be embedded and sort of hidden away in the decisional processes within the juvenile justice system, especially in Australia. And I find it interesting because it is how the risk factor race, so being a young person with an ethnic or migration background, makes it more highly risky to become a client of the system. And he develops that based on a lot of research, comparative research, also with the UK. Maybe we can go to the next slide. The third important moment where social inequality, discrimination plays an important role is, of course, the diagnosis moment. And this can be very at the early stage of procedural development with the judge, or even before that, where a sort of analysis is made, a diagnosis is made of the problem of the young person, the minor or the child that is taken into and taken up as a file into the juvenile justice system. Important is to know that this diagnosis, let's say, model is also something very scientifically very to be criticized, because these assessment tools, and Cunin in his analysis reports makes an analysis of the huge use of assessment tools within the penal system more at large, but the juvenile justice system more specifically, is the fact that these assessment tools are in fact tools that have a problem in the way they are constructed scientifically. So he points out at the self-fulfilling prophecy that in fact is in there, and maybe we can go to the next slide. I hope it's voila. So what he this critique of the assessment risk assessment tools from a criminological perspective is that, as I said before, social precarity characteristics are seen and taken up as risks. It's taken up as risk factors, because what these assessment tools are based on is the study of the clientele of a penal system, juvenile justice system, or the system for adults. So when you make a statistical description of the people who are in the system, in prison, for example, or in juvenile justice system, and you get these long lists of possible risk factors. So there is a sort of correlation between these social risk factors and the population that is in the system. But you understand, I hope you understand, the idea is the construction of the instrument is a sort of circle idea. We start studying those who are, for example, in prison. They have these characteristics. These characteristics become really correlations with the risk of being delinquent, of being someone who coming in contact with the juvenile justice system. And so you get a sort of self-referring tool that at each time, again, will reconfirm the characteristics of those who are in the system. So when in this sense, the risk assessment tools are a sort of self-fulfilling prophecy tool, where you get always the same kind of profiles that enter and reconfirm the idea of the basic risk factors. That is why also in the long term we can really say that these risk factor thinking in practice has become something really deeply embedded, not only in the, let's say, technical use of those instruments, but also in the, let's say, professional thinking of actors within the system. It's interesting to see how the results of those assessment tools kind of become part of decisional practices, but as a sort of proxy. So actors, magistrates, but social workers also, for example, use those as sort of confirming their own, let's say, more more informal, more intuitive vision on the problems of, in this case, a minor within the juvenile justice system. So you get this very bizarre way of how this has become a way of thinking. And one of the problems Cunin points out is, of course, that race, but also social inequality, becomes a sort of invisible, it's neutralized. It has become a risk factor, which is not anymore thought of as being linked to more structural and social or societal problems. So it installs a sort of constant idea, which has become a very difficult idea to let's say, discuss with professional actors, being the fact that there are some high-risk groups in society, and we all know them: young people from minority groups, from certain neighborhoods, and from let's say, poor, to generalize, poor social economic backgrounds and not doing well in school. And we can go on like that. We all know those classical risk factors. So these kind of tools need to be treated with a very critical eye. Can we go to the next one, please? The last point I want to pay a bit of attention to is, of course, young people get into this system. They have a file, they come before the magistrate, they come before the judge, they have a measure imposed. They have to be placed in institution or alternatives, whatever. But all this, let's say, contact with the system and being in the system, having a file, being a minor from the juvenile justice system has impact. And the discussion about impact can be seen in a lot of ways. Of course, there is the classical criminological and especially policy-driven arguments that these interventions need to have an effect, a positive effect, mainly being, and then it begins. What is the view? What is the perspective on this effect, this impact? In general, it has to be, or it is, a sort of, the diminishing of committing crimes, of course. So this idea of recidivism, the measurement of recidivism has been, at least at a certain moment, a very, let's say, translation of this idea of impact. But the studies that we have been doing and a more qualitative approach of impact demonstrates another kind of impact. If we approach impact as a more qualitative concept, we need to do another type of research, and we need to discuss within the system and with professional actors about impact. It's a very, for me, it's a very important point of the next conclusion being what to do. So it has impact always, and this impact can be very negative. Not because people are bad or bad professionals, or no. Impact, it can be what we call an impact that we did not want necessarily. So it's interesting for professionals to learn something from the young people that they are treating or viewing or deciding upon. That's why I wanted to focus a bit on this impact, because the impact the juvenile justice system has will have consequences for the adults that young people will become. These kind of impacts are impacts that make, precisely because we are talking about minors, precisely because we are talking about persons who are in transition toward adulthood, if you look at it from a sociological point of view. So this transitional phase, becoming an adult, will be, let's say, marked, impacted by this contact with the juvenile justice system. And if we can go to the next slide, I will not go into all the details of this slide, but there are a lot of elements on this research going into what is the experience of young people by asking young people about their experiences. So this idea of voicing young people's perspective and experiences. So they have not all young people have, let's say, positive experience with the judge or with the police. We know about these more negative experiences. Young people experience being with the judge not necessarily as something positive, where he or she has been hurt by the judge, and meaning not just that they could participate in a process, but that this participation had any meaning, had any impact on a decision. Real participation is very limited in the experience of young people. Being into youth care or being into this trajectory of all kinds of social care measures, both in institutions as also more in not in institutionalization trajectory, but also in other kind of more ambulant, how you say this, alternative care measures. We have them also in Belgium, and where you have a sort of reference social worker that you can always call and who will help you with some problems or conflicts you have, for example, in families, or in accompanying you when you need to go to school, the conflicts with others. So there are some other types of possible care measures than only institutionalization or being placed in an institution. And there also, one of the, I found it a very interesting research from Sharon van Oudenhoven, which is already some years old, but it was really very interesting research that showed how young people talked about their social workers and how they had this feeling of a long-standing lack of continuity in the relationships they had with adults, both professionals and non-professionals. They feel they are lonely. They have to be strong. They are not really prepared for something, the future, an adult future. They feel they will have a lot of problems, a lot of stigma to bear. They are not they have not experienced relationships of unconditional acceptance. So one of the big let's say vulnerabilities of young people coming out of the juvenile justice system is the problem of important, meaningful, informal social relationship, a network. Because, of course, the intervention of the juvenile justice system has a sort of difficulty of explaining and leaving informal social contexts of young people. For example, one of the rules in a lot of institutions is not to make friends. You don't have friends in the institution, especially when young people come into contact with the system having bad friends. So it's very difficult for young people leaving the care system or the juvenile justice system to be able to be strong because you have informal a social network where you can count on. So in a way, and the research of Sharon van Oudenhoven also indicated that, is in a way young people come out of this system and in fact are as vulnerable in a societal, sociological way as they were, as their parents were, for example. So that you have a sort of reproduction of social vulnerability, especially at the moment when this transition into adulthood is their moment in life. And we see that, for example, young people are at the end of their juvenile justice trajectory. It ends, and then they kind of flop into the adult world. And there is this whole discussion about how to deal with this transition from a more juvenile justice or social care perspective. So this connection between those two worlds is, from a point of view of the law, is not there, because you have juvenile justice system and the adult system of care, penally, etc. But people, they they have to bridge those worlds. And what we see, what Sharon van Oudenhoven shows in her research, is precisely that those people come into this adult world and almost immediately are confronted with a lot of problems which their parents also had. socioeconomically, having a degree, finding a job, finding an apartment or living, being able to pay an apartment. So there is this precarity, which is in fact not dealt with within the juvenile justice system. Not to speak from the stigmatization and the fact that you have this sort of this labeling. The fact that you have been a juvenile justice client is something that makes it's not that it defines you, but it's part of the process of who you become, who you can become. And so a lot of young people struggle with this becoming process. Can we go to the next slide, please? So this impact question is very important in a way, because it's the connection that is made between the effect of the intervention by the system and the way young people will leave the system, have a future and have a perspective on a future into their adult life. And a lot of these research that we have done ourselves at VUB, but also at Ghent, and colleagues of Sharon van Oudenhoven, demonstrates the same kind of general insights. There is a problem of the preparing young people towards this future. There is a problem of focusing on young adults, of preparing, schooling, of accompanying them into this adult world, and not from a social control perspective, but from a welfare perspective, and social rights perspective. It's clear that youth justice interventions not necessarily empower young people. That there should be, in a way, there is, in fact, within the juvenile justice system, a too big focus on or the crime, delinquent facts, or the problematic behavior, where you see that there is a necessity to focus on the future, on the possibilities of a young person, not keeping, let's say, too much attention to the past, but rather shifting the look towards the future. And there's this abrupt ending is a problem from an impact point of view, and dealing with social inequality, which not if this ending of this juvenile justice attention for the minor and his rights and his possibilities, if there is not really a sort of attention towards this becoming an adult, then you have a lot of young people kind of falling into a problematic living situation again. Can we go to the conclusion then, please? Maybe we skip this one. Well, okay. So what I would say is what to do then, and how to deal with this, knowing that the system, in fact, reproduces and not has a sort of systemic moments where inequality and discrimination is at play. How to act at that time? Can we change? And are children's rights an instrument, a possibility? I see it as a possibility of really to not just have a discourse on juvenile justice, on children's rights, on empowerment, on participation, but to become professionals that have a practice that is, let's say, led by this children's rights climate and professional acting. So I think it's necessary to have within the juvenile justice system this focus on doing children's rights. And knowingly being aware, this kind of professional awareness of the embeddedness of reproducing social inequality and discrimination. I am not saying that judges or police officers are knowingly discriminatory or knowingly. No, that's not what I'm saying. I think a lot of professionals know my story and my argument. The problem is how to change the way juvenile justice works. And I think children's rights can play a role in that. Another element, I think, and that's what I call here the denied conflicts in our society, is precisely to activate the discussion about these social conflicts, this inequality in society, and the way young people need to be helped to get at an individual level. But it's also sort of a political discussion in a way. It's a political conscience of and reflection of professional actors that we need to really change this sort of invisible working of social inequality and discrimination within the juvenile justice practices. And I will end it here, if that's okay.
Thank you very much, Jenneke, for a great presentation. I think it is very useful to be aware of the issues that exist, and good that you also ended on a positive note, sort of. So,
Yeah.
I think now we can open the floor to some questions. Jenneke will have to leave a bit earlier today, so please feel free to ask all the questions now, and then we'll continue with Idil and her presentation, and she will have more time to answer the questions. Is there anyone? You can also write in the chat, and I can read if you prefer.
Yeah, I maybe have a question. My name is Jorinda Temmink. I'm a Dutch lawyer, also for youth in the criminal justice system. And a lot of times I find that people really get entangled in all the measures being taken. And especially when a treatment is necessary, there will be a huge waiting list. And they are on this waiting list. And then as soon as they're from the waiting list, the problems have developed so much so that all the people around them, social workers and everyone, say, no, this has gone too far now. Let's put them in a home now. And I'm always really frustrated at how do we get to convince the judges that if you want to empower children, you don't put them on the waiting list and after the long wait say, oh, but we're sorry, we cannot help you anymore because you made things worse. And I find it very difficult to convince judges to give these children a chance to actually let the treatment help them instead of just offering them a place in a home where they cannot get out. And especially if all the social services say, well, this child really needs to put in a home now. There's no other option anymore. We tried everything.
Yeah. Yeah, I know the problem. We have the same problem in Belgium, especially with the waiting list. And this is sort of, I have the impression that the problems in society are getting that important, that this juvenile justice system, which historically could kind of deal with the difficult population, to say it now like that, but this is getting that enormous in within this system that this is coming to a sort of standstill. So you can look at it from at an individual micro level, but if you do that and you try to find solutions for an individual within this system, then it still is a sort of it's a sort of bricolage. It's not really a good let's say, based on children's rights, on possibilities, etc., decision-making process. It's a sort of bricolage where you have these young people getting from one place to another, trajectories which are completely, have a logic that nobody understands, and which makes the situation of young people rather worse. And we call them, there was a research at my French-speaking colleagues, they called it nomad. They used the word nomad because these young people, they have been more or less in all the corners of the system, in all the sort of measures that were possible, where there was some kind of place or a bed or but they became very, very difficult, of course, because each time they are redefined to be able to get into that place. So they become, from the system's point of view, very, very difficult. So if you look at it at the micro level, it is really becoming almost a desperate practice. But what fascinates me is that the system, the professionals of the system, are not are not voicing the structural problems of this system, because it is not just a problem of people and of investments and of rationalization, and because that's also part of this story. It is not just that we don't have enough places. There is an influx at the entrance because problems in society are really becoming more problematic. More people in poverty, more people with all kinds of problems, families, housing, access to, etc. The structural problems on the one hand, and on the other hand, you have all this way of dealing and system-wise, so more at the meso or even macro level, how the system has to deal with its fluxes, how difficult populations are managed, how many time social workers can have with clients, how well, the whole, let's say, easy let's say, labeling of, but the new management approach. So the whole system is kind of, is not able to resolve or to how you say this, to the system, in fact, is not able to make coming true what they proclaim or say their role is. So you get a sort of, faillite. You get a sort of, I'm really very pessimistic about it. In Belgium, or in Flanders at least, that we have a constant problem of places for young people. And so they are waiting. And everybody knows that if you wait with problems who are eventually psychological, who are really have to do with poverty, or they will not be, if you wait, they only can become worse. So there is really I think a necessary exercise of rethinking how this works at a more political system level. And it fascinates me how social workers in general, if you compare it, for example, to the 80s of the last century, are not really in a sort of, are not in this more political role towards a discussion on this system. I really found that very, maybe it's not an answer to your question, because you are dealing with individual children or young people, and everybody's fighting for their youngster. But of course, if you take the place that is open, then it means that there is another one who is not going to go into that place. So it's really, I think, a more political question. It's not just to make more places and more institutions. I think, yes, there is a necessity of investing in personnel. I don't know how it is in other countries, but it's a bit like with the discussion when we had with COVID. These are people that are have a very tough job. social workers, for example, a very tough job, but they are not paid accordingly, or it's really a heavy job, but it's not viewed as that. So when you are now in a society where you have these rationalizations and big crises, etc., it's not that kind. You can't find social workers. I'm part of an institution here in Brussels, which accompanies young people, sort of crisis center. They don't find the personnel for doing a job. There's, let's say, we had 3 years of looking for personnel to work in the system, and it's very difficult to find them, and nobody wants to do. I mean, and so you get this sort of more context of the system that has a huge impact on how doing juvenile justice. And of course, you say you want to convince the judge. Yes, I think judges have also their routines in general, and practices of decision making. I think there is a necessity of working with young people and families much earlier and much more as part of a sort of social policy which tackles social inequality, which tackles poverty, which tackles housing problems, schooling problems, etc.
Yeah,
So
more on the prevention side.
yeah, you can call it the prevention side. It's prevention when you look at it from the juvenile justice system. But of course, it is a societal social policy, because resolving problems outside of the juvenile justice system is always better, especially if you look from the point of view of impact, is better, has a better result. Keeping young people out of the juvenile justice system in the long run has a better effect than getting them into the juvenile justice system. So the non-interventionist motto, and of course it's a very difficult one, I know, but to at least have a sort of debate on that. We can't, all these societal problems, we can't resolve them with a juvenile justice system or a youth care system. And that is a bit, we as a juvenile justice or youth care system, we are part of this puzzle, of course. But it's not always the solution. And so yeah, I think it's really a huge political debate, which I don't have a solution for. I'm sorry.
Thank you.
Okay, maybe if there's one more question that we can address, and then we can move to the next presentation. Yes, Rianne, go ahead.
Hi, my name is Rianne de Bak, public prosecutor from the Netherlands in youth criminal law. We met each other this year in Brussels. Yeah. And I have a question about the risk assessment tools. Do you think that there's a possibility to change it into a good working tool, or is the answer that we have to abolish these tools? Because in the Netherlands, we have the question about the pre-select. That's the source of our assessment tools, and it's based on police contacts. Well, you told us all about the background of police contacts. So, well, that's my question. Is there an alternative, or do we have to work in another way and abolish these tools?
Yeah, well, I referred also to this new management and the idea of course, selecting which files go on and prosecute and which not, etc. And there is some interesting research on how in the past, and I speak about the 20th century, public prosecution selected and I'm not sure how you say this in English, CEPO, so the non-prosecution of files. it has always been it has always been a sort of Gordian thing that you have to slice and take a sort of the solution. And you can always, with risk assessment tools, you can win and you can lose, because you can prosecute a case where the risk assessment tool confirms that you needed to prosecute because it's and then there are others where you did not prosecute based on this kind of tools, and it went hugely wrong. So it is not necessarily. I'm of the position in a certain radical way that it is not a good instrument for public prosecutors or even judges to have a sort of to use it as something that is fundamental to their decision practice, precisely because there is this problem that it reiterates the selectivity of the system. I'm from the perspective that prosecution and decision making by judges, etc., is casework. So, of course, there are a lot of cases, and if it is to select, then you need to prioritize, and then is it a discussion about priorities? And priorities are more political, can be more like based on phenomena that change in society, but that you always have this falling back on casework. I'm in that sense, I would say, get rid of the risk assessment tool, or at least have a huge discussion on the basis of these risk assessment tools, which in general are also, you have to pay for them. So the use of it can maybe, and the budget of it can maybe be used in another way. And then the pre-select assessment, I'm not in detail. I know the concept, if I may say so, but I don't know in detail what is in it. So what are the criteria? Because that's always the thing. Which criteria play a role in the decision making? So the discussion should be, in my opinion, on the criteria for selection. And as you know, well, you are a prosecutor, so you know the importance of the, how would I call it, the police input. Not only on the selectivity of young people in general, and the attention they have for certain young people and not for others, to say it simply, but on the other hand, also the, let's say, the more qualitative, the meaning, the information, the way the file is constructed is also very important. So I think there is I mean, public prosecutors are not the police. So I think there is a need of a certain independence. However, I think that in practice, that independence or more sort of autonomy on the decision-making practice of each actor, and even if you go further on in the procedure, also it's important, I think. So the autonomy of an actor needs to be guaranteed in a way, and so relying too much on is problematic, I think, from a children's rights perspective, but also from a more professional perspective. So I think that's an interesting aspect to work on with colleagues, or if you have a local team, or the reflexivity on the professional reflexivity, that's correct. The professional reflexivity of a professional actor and a team on what they are doing. I think it's more up to that. I'm sure those tools are very handy and swift, etc. But qualitative perspective, I think they lead towards a sort of Yeah, I'm not quite sure that they lead to a qualitative, interesting result.
Thank you very much. And I know that in the Netherlands, a discussion will be organized about the basic fundamentals of this assessment tool.
Okay.
And I think it's very important. And I agree with you that we do not have to rely fully on the outcome of these tools.
Yeah.
So thank you for this knowledge.
It's a bit like with statistics, I find, because it's statistics. It can give you an hypothesis to work on. But that doesn't mean that you have to follow it blindly.
Yes.
So in that way, it can be, but of course, because it is handy, very, very fast, it becomes kind of, oh yeah, we follow it.
Yes.
And that's a dangerous slippery slope.
A risk in itself.
Absolutely, yes.
Okay.
Absolutely.
Thank you.
Okay, thank you very much for the questions and also for answers, Jenneke. Very useful. I hope our professionals can say the same. I think now we will start with Idil and the next presentation. Let me know if you can share the presentation, otherwise I will do this. So please, the floor is yours.
I will have to leave you. I'm very sorry. I want to apologize to my colleague speaker, but I have to go teach at 1 o'clock, so I need to kind of get on the bike and but big success for you too.
Thank you so much for the great presentation. And no worries, education comes first.
Okay.
I am trying to share my screen. Can you all see it?
Yeah.
Perfect. So I'm gonna. Yes, perfect. Hello everyone. It is so nice to be here and having the chance to share this presentation with you. I'm Idil Aydinoglu from Penal Reform International, and before starting my presentation on exploring alternatives to pre-trial detention for children in the criminal justice systems, I would like to quickly touch upon who we are and what we do. Penal Reform International is a Netherlands-based international organization working on making criminal justice systems more fair and effective and human rights oriented and applied in a non-discriminatory manner. We have 5 regions. We have offices in 5 regions, and I am from the Europe program. We are working towards systemic change, and we get together along with justice stakeholders in order to develop instruments that help them criminal justice systems to be more human rights oriented, which includes gender sensitive and child friendly approaches in the justice systems. This is the work we've recently done that highlights the type of instruments we're creating. We developed a data monitoring tool for facilities to monitor violence against children incidents in the detention facilities. And if you're ever interested, you can find our resources in our website. Okay, moving on towards the presentation. Yes, so before we start talking about the custodial measures and what are the alternatives to that, one thing we would like to point out is the criminal responsibility age and how they're linked, because it feels as if it's evident that the moment that a person becomes criminally responsible, criminally liable, the custodial measures come into place, which is in fact the reality when we look at the Fundamental Rights Agency's data. But it is important to keep in mind that this doesn't have to be the case. When we look at the EU member states, we see that the minimum age threshold for detention for any custodial measure ranges from 10 till 16. When we look at the countries who are part of this project, we see that the age ranges from it starts from 12 in Belgium and Netherlands, and it goes up to 15. And then we see in Poland there's a discrepancy. There's a breakdown of the age of criminal responsibility that are specific for that are specifically listed in a specific clause. This is just an overview of the countries that are in this project, but it gives us a chance to see the different groups only just from the age perspective that judges, prosecutors, and lawyers are working with. This is, I mean, I'm now at the age of 37, and what I change from last year to today, it doesn't really matter. But if you go back to Jenneke's presentation, the difference of these ages become much more critical in terms of maturity, in terms of understanding the conditions, and also being able to suffer the consequences, to being able to endure the consequences of custodial measures. And I hope all these numbers are correct. I took it from Children's Rights International Network, but please let me know if there is any missing information. So if we go to the principles of deprivation of liberty, we see this is the general principle of the child justice globally. It is the principle of using detention as a measure of last resort when it comes to children. When we look at the UN Committee on the Rights of the Child, we see that the committee recommends pre-trial detention to be used only in the most serious cases, and even after seeking opportunities for non-custodial measures. When we look at the numbers in terms of the time, we see that UNCRC recommends maximum 24 hours for a child to be brought before a competent authority for an assessment on the legality of their arrest, a maximum of 30 days for the child to be brought before a court for a legal review of the case itself, and the committee is also mindful about the reality of postponing hearings, the reality of lengthy cases, and there the committee urges states to adopt maximum of 6 months of limit for any criminal case where a child is accused of a crime. And in the same, this is from the General Comment 24, in the same document, we also see that the committee considers months, even years of pre-trial detention as a grave violation. So it is also important to recognize, to keep this in mind as a consequence of the measure, the last resort principle. The UNCRC considers that the use of pre-trial detention should be clearly the criteria of any reason of pre-trial detention should be very clear in the law, and which should be primarily primarily applied to ensure the appearance at the court of the proceedings, the child to be at the proceedings, or if the child is in immediate danger to others or themselves. So these are the only two criteria that the UNCRC considers. Of course, the wording is flexible, but these are the ones that are specifically mentioned. And one important thing as well is that if the child is posing a danger to themselves or someone else, child protection measures should be applied. Another important point in this regard is the fact that individual assessment as enshrined by Directive 2016/800. I'm going to call it as directive from now on, because that will be the only one I will reference in this presentation. Individual assessment regulated in Article 7 is one of the key issues to take into account while we're discussing detention or pre-trial detention, because this individual assessment too applies for pre-trial detention. States are encouraged, judicial practitioners are invited, are asked to follow the individual assessment findings. And these are not only, I mean, these can expand to from personality, maturity, child's economic, social, and family background, and any specific vulnerabilities that they may have. It is also important to maybe go back to the Fundamental Rights Agency's opinions, because they analyze the data they gather from the EU countries. They highlight that even if most countries reference the age, they do not specifically focus on the maturity of the child, of the young person involved, which is another factor in any decision that is making on their behalf. So against this background, the directive, European rules for juvenile offenders, and UNCRC and many other international documents recommend states to, where possible, apply alternatives to detention. What are non-custodial measures? What are alternatives to detention? Before listing them down very quickly, I would like to touch upon one important thing. This really complements Jenneke's presentation, because she too mentioned the importance of diversion programs and how it is important to keep children out of the criminal justice system. So when we talk about non-custodial measures or custodial measures, we're talking about the second phase where the available diversion measures didn't work. So very, very important to have a variety of diversion measures that can be applied for children. Of course, when we talk about non-custodial measures, it is providing alternatives means of supervising children who are in conflict with the law pending their trial, rather than placing them in a police station or pre-trial detention centers. Jenneke has mentioned it significantly, so I do not want to jump that much in detail, but we have significant data showing that once a child is in detention, their whole the prospect of their life significantly changes. So any measure that can prevent it is significantly important. So what could be these measures? We know that the international documents and instruments heavily rely on the children to be released to their parents and caregivers. In this regard, they can be released with or without certain conditions. We see that the child can be entrusted to the parents and caregivers, and they could also be required to report regularly to police station or probation officers. They can be required to stay home at a certain hour. They can be, their attendance to school can be mandated and can be supervised by an authority. Their attendance to a specific place, perhaps any support programs, any anger management programs that is available in your respective countries. There could be periods of curfew that they are not allowed to leave the house or the premises that has been identified by the judicial authorities. They can be required not to associate with certain people that they might be in friends with and who probably might have led to this condition. and they can be required not to go to certain places, which also limits their liberty, but of course to a very, very limited limited version compared to detention. So these possibilities they can be increased, they can be decreased depending on the available options in your respective countries. However, one thing that is really important here is also the UNCRC's general comment number 24 that states that there should be a discretion on the judicial authorities and also the legislative authorities to create to issue these decisions, and they should be done on a case-by-case basis, and of course by considering the best interest of the child, which is the overarching, the paramount principle that is required to be applied throughout all of these decisions. If none of these measures are not adequate, or they seem to be very limited considering the severity of the case, close supervision, intensive care, or placement with a family or foster parents can also be an issue. These three options can also include other state institutions if these are already in place in your countries. One issue that can stand out is if the child and the family's connections are creating the reason of children being in conflict with the law. And there, of course, child protection services needs to come into place to make sure that the child is not engaged with the ongoing relationships with the factors that make them being in conflict with the law in the first place. So these are the options, but we also want to always underline the human rights risks that result from the application of non-custodial measures, because we need to be mindful about the practice for example, when we look at the adults and how non-custodial measures have been applied, we know that there is a big risk of net widening. After the application of non-custodial measures, we see that in some countries, the number of people involved in the criminal justice system has increased significantly. In some, they doubled up. So one important thing is to make sure that the non-custodial measures are implemented in place of custodial measure, not for young people or people who were supposed to be released without any supervision. So that is an important point. There could be inadequate non-custodial measures. One of them is payment of bail. Payment of bail is never recommended for children who are in conflict with the law. For one thing, children are typically they do not have money, which makes them dependent on their parents, who might not prefer to pay and who might not have the ability to pay. And overall, for the risk of discrimination, payment of bail is not recommended. And another key factor is the vulnerable groups. We have been working around the application of non-custodial measures for some time, and we see in certain countries that some measures do not really serve their purpose when it comes to some groups. For example, electronic monitoring was one measure that seemed quite impact people quite disproportionately. If, for example, Roma people or people who do not have a house, a residence permit, are typically excluded from the application because they do not either have electricity or they do not have an address to show. So they can typically find themselves in custodial measures rather than non-custodial measures. So the application of non-custodial measures could require some creativity. If a child is in the same situation, if a child doesn't have a parent, or their guardians do not provide the safety as you would hope to have, that means that there could be other options for that child to be out of prison rather than just following the typical path and placing them in detention. This was so I also want to talk about other additional factors that come into place. This was asked to Jenneke, and this is not in Europe, but our colleagues at PRI, they've realized the strength-based assessment tool rather than a risk-based assessment one, which looks at the positive things that impact children and their relationship with the outside world. These include some areas that needs improvement, but the questions and the type of data are structured in a way to highlight the achievement and the potential ways to make the child more integrated with the society, and in a way it aims to kind of shift that narrative that was discussed at the very end of Jenneke's presentation. So this is one key factor that we found very important. The other key factor I would like to mention is the having strong and diverse diversion options. For example, in Ireland, I think in 2024 or 23, there were around 15,000 people young people who were diverted from the system, and the Overstown Child Detention Facility, which is the only one in the country, has the capacity of 90 children. So they do heavily rely on their diversion program, which throughout the years has decreased down the population of children in detention in the country. Of course, they also have pretrial detainees in the facility, but just as a good promising example to show how diversion programs can actually be useful. Reluctance to take risk is another factor that we've observed among judicial practitioners. Even in some cases where there's a promising report, where there's a social inquiry report that indicates the child can be released, in some cases, we see that judges and prosecutors choose the safe road, in quotation marks, of course, to keep the child until the procedures end or until their sentences end. So this shows that, of course, no one is. I mean, this doesn't come from a bad intention, but it shows that there is a need for a broad policy level support to every stakeholder in the system to make these kind of decisions easier, and perhaps a multi-stakeholder strategy to make sure that these different bodies who are taking in charge of this procedure, they talk to each other and they know they complement each other's work. Last two legal representation and remote hearings they might seem very relevant, but this is something we are currently working on as a project, so I wanted to briefly mention. Legal representation is something that every child has the right to have a legal aid. But in practice, we've came to realize that most children are never consulted or never had received advice from their lawyers before their trial. This was something that was quite interesting. And of course, lawyers have their own strategy. Maybe in some cases, this is not something that is so needed. But I'm also a lawyer, and I have the feeling that seeing a client, especially a child, to prepare them for a case could be an important factor. And it is something in my head, it's a very mandatory thing to do, especially in the case of children. So one thing that to keep in mind could be whether the child is prepared for the case and how that could impact their attribute, their behaviors in the proceeding. This also applies for the remote hearings, because we have realized that, especially in remote hearings, children feel extremely not all. Some children find it very good, but in some cases, children say that it feels like watching a YouTube video. So we strongly propose not to make such decisions, like decision to have a pretrial, the decision to put a child in pretrial or not. We strongly advise that these not be realized in remote hearings, but in person hearings, and making sure that there's that the child had received all the support and information regarding the proceedings prior to their hearing. And one last thing, I suppose it's again resonates with Jenneke's presentation and the last question. It's about investing financial resources and supportive policy. It is a choice, investing in child detention facilities, making prisons, because they're not coming from outside the world and they just happen to be there. This is also an investment, and I suppose a stronger voice from the judicial practitioners, also advocates in the child justice system, in channeling these resources to a more protective and strength-based and empowering child justice system that focuses on reintegration of children, that aims at keeping children outside of the detention facilities as much as possible, is a decision that hopefully will get back on track. I know everyone. I know many people are not hopeful in this regard, but I think it's good to keep hope high. So this is the end of my presentation, and I hope I didn't take too much of the time, but okay, I have to. Sorry, it was longer than I was supposed to. Yes, please, I can stop here.
Thank you very much, Idil. Very detailed presentation, which I think is already good since you addressed quite a lot of interesting points. I think we have a couple of minutes for questions. So please, if anyone has anything to ask, go ahead now. Okay, I think I will share the presentation if our speakers allow after the webinar. And if there are no questions to Idil, I might then just quickly wrap it up. So we discussed important issues today. And as I mentioned, this webinar was a part of the Access project, and there are a couple of upcoming activities. We're going to publish the Compendium of Good Practices, which combines the practices that we discussed during the project meetings, including this webinar as well, on what is the best way to ensure the access to justice for children who are in criminal proceedings. We're also going to publish the frequently asked questions for children and youth and their parents to make them better equipped with the knowledge of their rights. And there are also going to be national workshops happening in a couple of following months. So you can stay in touch and keep a track of what's happening within the project if you are interested. We're happy you could join us today, and thank you for your participation. Wish you a great day. I will also share the feedback form after that. So please, it would be very helpful for us to know whether, if you have any comments on what could be improved, or if you liked the presentations and in general the content. Thank you very much, and yeah, wishing you a great day.